Courts are quietly rewriting the rules of American business, and your wallet is directly in the crosshairs.
It's it really is a massive architectural shift in how this country operates.
Welcome to today's deep dive, everyone. We are going to unpack this shifting legal landscape because, well, the ground beneath our entire regulatory system just sort of gave way.
Yeah, big businesses. We're talking massive players like Monsanto, Verizon, Cisco. They are all currently lining up at the Supreme Court.
Right. And to understand why, we have to look at some recent major rulings. Like in a case called Loper Bright, the Supreme Court killed a 40-year-old legal doctrine known as Chevron deference.
Which is huge. I mean,
Yeah.
for decades, if Congress passed a law that was even slightly vague, the courts just deferred to the scientists and experts at government agencies.
Right. They let the agencies fill in the blanks.
Exactly. But now,
Yeah.
judges no longer have to blindly defer to government agencies.
Yeah.
So if the EPA wants to regulate a chemical or, the FCC wants to find a telecom giant, they just don't automatically get the benefit of the doubt anymore.
And then you have another massive case, Jharkhasi, where the court stopped the Securities and Exchange Commission from using their own in-house judges for fraud penalties.
Right. They demanded jury trials instead.
Mm-hmm.
So the bottom line is that massive amounts of power just shifted away from federal regulators and moved directly into the hands of judges and juries.
Which touches literally everything from the warning labels on weed killer to the fines you pay on your phone bill.
Yeah, it really does. And our goal for this deep dive is to sort of map out the financial math of that power shift.
And just to be super clear with you listening, we are maintaining strict neutrality here. We are not debating the politics of these rulings.
Right, we're definitely not taking a side on whether moving power from agencies to courts is a good or a bad thing.
Exactly. We are simply looking at the reality of the source material. We want to connect the dots and show you how this sheer unpredictability in the court system impacts the broader economy.
And how, massive state-level jury verdicts eventually trickle down into the price you pay for everyday goods.
So if power is rapidly moving into the courtrooms, I guess the most logical first question is, how well do we actually understand what those courts will do?
Right. If judges and juries hold the cards, can we predict their next move?
Well, to figure that out, we should probably look at the most sophisticated prediction engine on Earth, which is the stock market. I mean, Wall Street spends billions of dollars building algorithms to anticipate the future, right?
Yeah, they predict global supply chain disruptions, shifts in consumer spending, international conflicts.
But the data reveals this massive blind spot when it comes to the legal system.
It really does. There's this fascinating study from researchers at the City University of New York. They analyzed over 500 Supreme Court cases involving publicly traded companies.
Wow, 500. That's a lot of data.
Yeah, looking at data stretching all the way from 1946 to 2018.
Yeah.
And they tracked stock prices during 3 very specific moments.
Okay, what were the moments?
First, the day the court agrees to hear a case. Second, the day the lawyers actually argue the case. And third, decision day.
And the numbers they found completely defy logic. Like, when the Supreme Court simply agrees to take a case, the stock prices of the companies involved immediately drop.
Yep. They drop by roughly 0.53 to 0.70%. And the wild part is, it doesn't even matter if the company is the one who filed the lawsuit or the one defending against it.
Wait, really? Both sides just instantly lose value.
Both sides, instantly. Which tells us a tremendous amount about how the financial sector views litigation.
Basically, the mere act of entering the courtroom destroys value.
Exactly. It's viewed as an unhedgeable, dangerous gamble.
Okay, let's unpack this a bit more. It's kind of like watching sports where the odds makers literally have no idea who will win until the final buzzer. Because when we look at the second moment, the oral arguments, the market basically shrugs.
Right. The lawyers are standing at the podium, debating the facts, answering questions from the justices. You would think the market would react to who had a better argument.
But the stock prices barely move.
They don't. And then we hit the third moment, decision day. The second the court announces the winner, winning stocks suddenly jump 0.55% and losing stocks drop 0.37%.
So Wall Street clearly has no idea who is going to win until the final gavel drops. But why do these highly advanced algorithms fail so completely here?
Well, what's fascinating here is that investors view the Supreme Court as a complete black box. The sheer cost of legal fees, the years of distraction for the executive team, and just the absolute uncertainty of a human judge. I mean, everyone loses value the second they step into the arena.
So, but I'm understanding this right. Wall Street models rely on past behavior, hard math, quantifiable data.
Right.
But a Supreme Court justice is applying human philosophy, textual interpretation, subjective history. You just can't put originalism into an Excel spreadsheet.
Precisely. And that jump on decision day is the ultimate proof of that surprise. I mean, if the market knew a company was going to win based on a strong oral argument, the stock would have gradually gone up weeks ago.
Because efficient markets price in expected outcomes.
Exactly. The fact that the stock violently jumps on the very last day proves that investors treat the highest court in the land as fundamentally unpredictable.
So, since we know courts are unpredictable black boxes, let's look at one specific billion-dollar gamble sitting inside that box at the Supreme Court right now.
Yeah, this is a massive battle over generic drugs.
And it affects literally anyone who fills a prescription at a pharmacy. The case is called Hikma v. Amarin.
Right, so the center of this fight is a drug called Vascepa, which is manufactured by Amarin. It's a highly purified fish oil pill used to treat patients with severe heart risks.
And Hikma is a generic drug manufacturer, right?
Yeah, and they created a copycat version of Vascepa using a very specific legal shortcut called skinny labeling.
Let me see if I can explain the mechanics of skinny labeling, because it's actually a brilliant concept. Imagine buying a software subscription. You download the whole program onto your computer, but you only pay for the basic features.
Okay, I follow.
The code for the premium features is physically sitting right there on your hard drive, but legally, you are only allowed to use the basic version.
That is a perfect way to visualize it. When a brand name pharmaceutical company creates a drug, they might hold multiple patents for different uses of that exact same molecule.
And eventually, the original patent expires.
Right. Over time, the patent for the original use expires, but they might still hold active patents for newly discovered uses. So skinny labeling allows a generic company to ask the FDA for permission to sell their cheaper pill solely for the unpatented uses.
They just carve the patented uses completely off their warning label.
Exactly. They carve it out.
And doing this bypasses incredibly long monopoly periods. I mean, the financial impact of this software-style workaround is staggering. When a generic competitor hits the open market, drug prices plummet by as much as 85%.
Oh, absolutely. The sources show that skinny labeling saved Medicare nearly $15 billion between 2015 and 2021.
$15 billion.
Yeah. And in just one single year, a generic version of the cholesterol drug Crestor launched early, specifically because of a skinny label. And that saved patients and insurers over $8 billion.
Wow. But the Vascepa case exposes the vulnerability of this whole system, because Amarin, the brand name creator, sued Hikma, the generic creator, for a legal concept called induced infringement.
Right. Amarin argues that Hikma's generic label, along with their marketing materials, implicitly encouraged doctors to prescribe the cheaper generic pill for the uses that Amarin still holds active patents for.
Here's where it gets really interesting, though. How does a generic company actually force a doctor to do anything?
Well, they don't, really.
Exactly, because when a doctor writes a prescription, they just type Vascepa or fish oil into their computer. They do not specify which exact patent claim they are targeting. The pharmacy system automatically substitutes the cheaper generic. It's totally automated.
And that is exactly the generic company's defense. Hikma argues they simply put out a standard press release bragging about the total market size of the drug, and they followed all the FDA rules for the carve-out label.
But Amarin claims what? That by boasting about the drug's broad cardiovascular benefits, Hikma was deliberately winking at doctors.
Basically, yeah. Amarin says Hikma knew full well those doctors would prescribe the generic for the still patented heart risks.
You can see the sheer tension here. I mean, Amarin makes roughly $1 billion a year off Vascepa. It is their flagship product. They spent millions running clinical trials to prove this fish oil prevents heart attacks, so of course they want to protect their intellectual property.
Naturally.
But if a vague press release is enough to trigger a massive patent lawsuit, generic companies are just going to stop trying. Is a generic company using a vague press release really twisting a doctor's arm, or is the brand company just protecting its golden goose?
Well, over 70 legal scholars, along with the Solicitor General of the United States, weighed in on this exact point. They argue that if the Supreme Court rules in favor of the brand company, the heightened legal risk will effectively kill the skinny label pathway.
Because generic manufacturers operate on such thin margins.
Right. They will not risk hundreds of millions in litigation over a marketing brochure. And if skinny labeling dies, patients will be forced to wait years or even decades longer for affordable medicine.
Yet the brand companies make a totally valid economic counterargument. Discovering a new use for an existing molecule costs an astronomical amount of money in research and development.
It's a huge investment.
Right. So if a generic company can just exploit this legal loophole, knowing the automated pharmacy system will hand out the cheap generic for the newly discovered use anyway, it destroys the financial incentive to innovate. Why would a company spend $1 billion researching a new life-saving use for an old drug if the law refuses to protect their investment?
It is the ultimate collision between the drive for medical innovation and the immediate need for patient access. And right now, the rules of that road are being decided by 9 justices in a system that, as we just saw with the Wall Street data, is fundamentally impossible to predict.
But this profound unpredictability is not just a federal issue happening in Washington. While the Supreme Court wrestles with pharmaceutical labels, state courts are quietly generating massive financial shockwaves of their own.
Yeah, they really are.
Which brings us to what legal watchdogs classify as judicial hellholes.
Right, so the American Tort Reform Foundation publishes an annual report analyzing jurisdictions where the scales of justice appear to be, well, heavily tipped.
And in 2023, they named the state of Georgia as the #1 worst jurisdiction in the country for litigation fairness.
The worst.
Earning the #1 spot on a list like that requires some extreme data. What exactly is happening in Georgia courtrooms?
Well, if we connect this to the bigger picture, the primary driver is the sheer frequency of nuclear verdicts.
And just to clarify, the legal industry defines a nuclear verdict as any jury award exceeding $10 million, right?
Exactly. Between 2013 and 2022, Georgia produced the 5th most nuclear verdicts in personal injury and wrongful death trials nationwide. Wow. And when you adjust for the size of the state's population, they rank 4th per capita. But the size of these specific awards is what truly stands out. The median nuclear verdict in Georgia right now is $24 million.
Wait, the median?
The median.
That means half of these massive verdicts are significantly higher than $24 million? That is insane.
It is. The sources detail a $1.7 billion punitive damages verdict against Ford in a product liability trial.
$1.7 billion.
Yeah. And there's another case where a CVS pharmacy was hit with a $43 million negligent security verdict just because a customer was tragically shot in the store's parking lot.
So what does this all mean for you? Because these verdicts generate shockwaves that extend far beyond the specific companies involved.
They absolutely do. A comprehensive study by the Brattle Group analyzed insurance market data and calculated that the civil liability system cost the state of Georgia an estimated $19.9 billion in the year 2022 alone.
To put that abstract number into perspective, when you divide $19.9 billion by the number of households in Georgia, it results in a hidden tort tax of $5,050 per household every single year.
That is a massive hit to the wallet.
Right. And this $5,050 isn't a bill you get in the mail. It acts as an invisible fee that gets baked right into the cost of your groceries, your apartment rent, and your auto insurance premiums.
Because businesses simply take the massive costs of these jury payouts and the skyrocketing insurance premiums required to survive them and pass them directly down to the consumer.
To really grasp how this happens, we have to look closely at the underlying legal mechanics. Why are Georgia juries awarding amounts so much higher than the rest of the country?
Well, the sources identify several unique features of state law driving this inflation, and the most prominent is the mechanism behind phantom damages.
The mechanics of phantom damages are fascinating because they stem from something called the collateral source rule. Explain how this actually plays out in a trial.
Okay, so under the collateral source rule, if you are injured and sue for medical costs, the jury is generally not allowed to know if your health insurance already covered the bill.
Which sounds crazy, but the original logic behind this rule was actually quite sound, right? Lawmakers decided that a wrongdoer should not get a financial discount just because their victim was responsible enough to purchase good health insurance.
Right, I understand the initial logic too. I mean, if you pay hefty premiums for a decade to maintain great insurance, why should the person who crashed into you reap the benefit of your foresight?
Exactly. But the execution of this rule in the modern healthcare system seems completely broken.
It is. Because of modern hospital billing, a jury is often shown the initial sticker price of the hospital invoice. However, health insurance companies never pay the sticker price. They negotiate massive, predetermined discounts. So a jury might see a medical bill for $500,000 and award that full amount to the plaintiff. But in reality, The plaintiff's health insurance company fully settled that exact bill with the hospital for only $100,000.
Wow, so the plaintiff legally pockets the $400,000 difference.
Exactly. Those are the phantom damages. It's money awarded to compensate for a bill that literally no one ever paid.
You literally have juries calculating multi-million-dollar payouts based on pure fiction. And the sources point out another mechanism driving these verdicts, which is the seatbelt gag rule.
Yeah, this is a remnant of state law from the 1980s. If a driver is severely injured in a car crash and sues the automobile manufacturer claiming the vehicle was defective, Georgia law explicitly prevents the jury from being told whether or not the driver was wearing a seatbelt at the time of the crash.
Let me get the historical context straight here. In the 1980s, seatbelt usage was not universally mandated, and cars didn't have alarms relentlessly buzzing at you to buckle up. Lawmakers at the time felt it was unjust to let a massive car company off the hook for manufacturing, say, a dangerous brake line, simply because the driver was not wearing a belt.
That was the original legislative intent, sure. But fast forward to today, when seatbelt usage is universal and fundamentally alters the physics of a crash, this rule acts as a blindfold on the jury.
It makes no sense today.
It doesn't. They are tasked with determining exactly who is at fault for the severity of a person's injuries, but they are legally barred from knowing the single most critical piece of safety information. It severely handcuffs the defense and often leads to disproportionate damage awards.
And throwing gasoline on all of these outdated rules is the relatively new phenomenon of third-party litigation funding, or TPLF.
Oh, this is a game changer.
We are talking about Wall Street firms, hedge funds, and private equity essentially buying shares in local lawsuits.
It fundamentally alters the psychology of a trial. Historically, a lawsuit was a dispute between two parties trying to find a fair resolution. Now, external investment funds front the money for the plaintiff's legal fees and living expenses in exchange for a substantial percentage of the final verdict.
And when you introduce outside investors who demand a high rate of return on their capital, the math of settling a case changes entirely.
It makes perfect sense from their view. If a plaintiff has a hedge fund backing them, they are heavily discouraged from accepting a reasonable early settlement offer.
Because the investors need a massive payout to justify the risk.
Exactly. Which pushes the plaintiff to roll the dice and go all the way to trial, hoping to hit one of those $24 million nuclear verdicts. It transforms the civil justice system from a mechanism for dispute resolution into a speculative financial market.
Which brings us full circle to that $5,050 invisible fee. The governor of Georgia recently proposed a legislative package attempting to reform these specific mechanics, seeking to eliminate phantom damages and allow juries to hear the facts about seatbelts. But changing an established legal economy is a fiercely contested battle.
It's going to be a tough fight for sure.
Well, we have covered incredible ground today. We started with the Supreme Court actively pulling authority away from specialized federal regulators, shifting that immense power directly to judges. We looked at 70 years of data proving that not even Wall Street algorithms can predict how those judges will rule because human philosophy just cannot be quantified.
Right.
We saw that unpredictability threaten the entire generic drug market with the skinny labeling battle over fish oil patents. And finally, we looked at the state level, where unpredictable courts directly drain thousands of dollars from household budgets.
Which leaves us with a critical new angle to consider. I mean, we've talked extensively about how unpredictable courts impact consumers. But what does this mean for corporate behavior?
That's the million-dollar question.
If regulatory agencies no longer provide clear, upfront rules for companies to follow, and the courtroom has become a speculative market fueled by third-party capital, how do companies adapt?
Do massive corporations eventually just stop pouring their capital into engineering, research, and innovation?
That's the fear. Do they take those billions of dollars and divert them entirely into defensive litigation funds, higher insurance premiums, and teams of lawyers simply to survive the volatility?
Wow.
Are we trading the annoying red tape of government bureaucrats for the complete, unpredictable chaos of the courtroom? We might be watching the U.S. economy slowly transition from an economy based on building things into an economy based entirely on litigating things.
That is a staggering thought to end on. Thank you so much for joining us for this deep dive. Keep asking the big questions, keep looking past the surface-level headlines, and remember, whether you are filling a prescription or buying groceries, the shifting rules of the courtroom are already priced in. Catch you next time.